Welcome back, guys. It's SM Kitsao. We're going to be looking at jurisprudential content. We'll be looking at judgments that have been delivered by superior courts. Look at classic cases. We'll be looking at notorious cases and cases of general public importance. So, in today's episode, we'll be looking at a Supreme Court judgment that was very, very controversial. The case of Fatuma Athman Aboud Faraj versus Ruth Faith Mwawasi, Judith Malele Mwawasi, Malin Koram Ponali. So this one, it's a case that I've decided to look at today because it's a case that has reaffirmed the supremacy of the Constitution in the hierarchy of laws in our jurisdiction. Then it has also contextualized the applicability of Islamic law to personal law of the people who confess or profess the Islam religion. Then also it has reaffirmed the rights of children under Article 53. Then it has also pumped more life into Article 27. So the background context of this case, just to give you the perspective, there was a man who was Muslim who married the first wife, married the second, and then married the third wife. So the first wife, they first cohabited with the man without formally getting married. Then they got a kid. They got children out of that cohabitation. Though prior to the cohabitation, the wife had come with a kid from another relationship she had had. So there was that kid that was not biologically belonging to the husband. Then other I think two more kids were born um, during the cohabitation, but before the formalization of the marriage. Then, sometime in 2011, I think, she formalized the marriage under Islamic law with the husband. At the same time, the husband married now the first respondent, Ruth Faith Mwawasi, and they got a kid with her. Then, lately, he got married now to the third respondent, and they also got a kid. So when this man died, the first wife filed a case in the Qadhi's court for succession, of course. Then the first respondent filed a case in the High Court seeking um, letters of administration of the estate. And in both cases, or in both instances, both petitioners cited themselves and their kids as the sole heirs of the estate of the deceased. So, of course, the second respondent is the sister to the husband. Together with the appellant in this case, they objected in the High Court the issuance of the letters of administration. So with that, the High Court judge merged the cases, that one in the Qadhi's court and the one in the petition in the High Court. So it became one case, which was determined conclusively. And the judge appreciated that Islamic law is only limited to the jurisdiction of the Qadhi's court, but went ahead to apply it as the applicable law because the parties there, it was evident that they professed the Islamic faith. So, in the substance of the matter, the court considered Islamic law, and yeah, in its judgment, the High Court declared, or it found that the firstborn of the appellant, who was the first wife, was not a biological son of the deceased, and therefore he was not entitled to the estate. He affirmed that both the children born during the cohabitation and those that were born during the subsistence of the marriage after formalization were both entitled to the estate of the deceased. They were four in number. Then the first respondent, her marriage was a bit shaky because of some of the conversion to Islamic State and to Islamic religion and all that. But the court affirmed, after it looked into the matter, it affirmed the constitutionality or the validity of the marriage, and therefore, together with her son, they were entitled to the estate of the deceased. Then for the third respondent, who was now this wife that was married lately, the court found that she had actually been charged with bigamy because at the time she was getting married to the deceased, she had another subsisting marriage, another subsisting civil marriage. So she was incompetent to marry. So because of that, the court held that she's not entitled, together with the kid, to to inherit the estate of the deceased. So of course they were aggrieved. The first respondent was aggrieved in the manner of the court's consideration, and they approached the Court of Appeal. Then the Court of Appeal reaffirmed the position of the High Court, and the first wife was aggrieved even more. So they approached the Supreme Court. Now it's right law, and we both know how you approach the Supreme Court, because it's not an open forum. It's either by a matter which is as of right due to interpretation of the Constitution, and one that is certified as one that is of general public importance. So they approached, of course, they coined this matter as one that demands the interpretation of the Supreme Court, of the Supreme Court's intervention in interpretation of the Constitution. And majorly of focus, it was Article 24.4. So that's the catch. Now that's where I want to delve in. So the Supreme Court, in its consideration, it looked at Article 24.4. Let me read Article 24.4 so that we get the context. I'll read it verbatim. So Article 24.4 says, the provisions of this chapter on equity shall be qualified to the extent strictly necessary for the application of Muslim law before the Qadi's court to persons who profess the Muslim religion in matters relating to personal status, marriage, divorce, and inheritance. So that was the bone of contention, because it is the same article in the whole chapter of Bill of Rights that qualifies the the equality provisions on equality from applying to personal law of Muslims. So the court now considered in its entirety and contextualize the interpretation or application of Article 24.4. And that's what I want to delve into right now. So firstly, the Supreme Court considered the history of Article 24.4. What is the history? When you look at the final report of the Committee of Expert on Constitutional Review, the one that was published in 2011, you'll realize that prior to the 2010 Constitution, the application of Muslim law to personal law of people confessing the Muslim faith was already constitutionally provided for. So it was a debate whether they should incorporate it in the new constitution or they should not. But finally, they decided that we should incorporate it so that we recognize the diversity that we have religious wise. And also, the main reason was that the provisions on equality, that is Article 27, the provision on equality were informed by Judeo-Christian concepts. Because remember, in Islam, they don't entirely believe in equality. I'm saying so because some of the Quranic provisions are not entirely on the tenets of equality. Some are obedient to the gender roles, some are obedient to societal standards. For instance, when you look at the distribution of estate of a deceased man, the males get double the share of the females in the same class. For instance, when you're looking at primary heirs, let's say the kids, those are primary heirs. The son will get double the share of the daughter. Then let's look at the wife and the husband. The husband is entitled to half the share of the estate if there are no kids. If there are kids, he is entitled to a quarter. Then half of that, the wife is entitled to an eighth if there are kids, then a quarter if there are no kids. So you look at some of those Islamic principles don't really marry with the Judeo-Christian precepts of equality. That's why there was this qualification under Article 24.4 that the provisions of this Bill of Rights on equality should be qualified when they are being applied to Muslims. So that was the main bone of contention. So the Supreme Court now was of the view that, and this is a view that I agree with them, this specific provision has internal qualifiers. Let me read it. The provisions of this chapter on equality shall be qualified to the extent strictly necessary. That's the first qualifier. The extent must be strictly necessary for the application of Muslim law before the Qadhi's court. So it's about application of Muslims law before the Qadhi's court. Then between persons who profess the Muslim religion, and limited to matters of personal status, marriage, divorce, and inheritance. So those were the qualifiers. And of interest, because most of these other qualifiers, the court found that this decision was well within. Of course, they were not contested. All the parties were professing the Muslim religion. It was between. It was relating to personal status, about succession, and also the matter had not necessarily been before the Qadhi's court, but the court applied Muslim law. So the only part that the court concerned itself with was the first qualifier, to the extent necessary, strictly necessary. So it employed some constitutional borrowing. Um, it considered international conventions. It considered other constitutions from other jurisdictions which embody a similar uh, phrasing or a similar provision with similar qualifiers. So it's in its definition, the extent strictly necessary uh, was a qualification that demands to check the qualification of this limitation on the principles of reasonability. When you look at Article 24, it's on the limitation generally. So when it guides how rights should be limited, and it gives the tenets that should be considered in limiting a right. So in essence, this first qualifier was referring back this provision to the reasonability test under Article 24(1), in the sense that we have to look at the purpose of this limitation before we can flag it as necessary or unnecessary, reasonable or unreasonable. So with that, the court brought back the applicability of Article 27 on equal benefit of the law and equal you should be treated equally before the law. So the consideration of the court here then was that the main reason that this is a bone of contention is because the Quranic provisions forbid kids or children born out of wedlock from inheriting the estate of their father. It provides that kids born out of wedlock should inherit from their mother. And the Supreme Court then was of the view that what is of essence? Because in this, and it limited itself in the circumstance of that case. So in the circumstance of that case, we have children who were born by the same parents during the cohabitation, but before the formalization of the marriage. Then we have the same persons giving birth to kids or children during the subsistency of the marriage. Want to treat differently these two sets of children, and they are born of the same biological parents and during the cohabitation. So that was the circumstance under which this judgment was considered. So the court was of the view that there's no particular constitutional provision that should be interpreted so that to contravene another constitutional provision, whereas the constitution should be interpreted holistically so that each provision of the constitution complements the other. And in that, it brought in the application of Article 53 on the rights of a child, that a child has to benefit from parental contribution from both parents. When you look at the constitution, when you look at the Quranic provisions, they are though painting the kid to be a child of the mother more than it is a child of the father. Whereas this same father was very aware of the same Quranic provisions on infidelity, but they went ahead to conduct an infidelity whose action have not bore this quote in quote um, illegal child or illegitimate child. So the essence I want to believe of the Quranic provisions was to curb infidelity. But why curb infidelity? By punishing those who did not even participate in the in the infidelity itself. Because remember, a kid does not make an application to be born. They don't request to be born by specific parents or in a specific manner, whether legitimate or illegitimately. Kids are not in control of that. So why the innocent child should suffer from being disentitled the inheritance of their father's estate just because their father was conducting in an infidelity, and now they're thrown to only, or they're limited to only enjoy or benefit from their mother's provisions. So that was the contention on human rights perspective, which I agree with. And when you look at it from the moral part, or I'll say religious part, when you look at it from the religious perspectives, what is of great good in trying to curb infidelity? Is it that you should punish those who conduct in it, or the products of infidelity? Because again, remember, this child will bear the tag of legitimacy, but the parent will go scot free. So, to my thinking, if the Quranic provisions are to achieve their purpose, then it has to be complemented by this constitutional, by this judgment of the Supreme Court. Because then, at the back of my mind as a Muslim man, I'll know if I engage in an infidelity, I'll have to bear the consequence of providing for that child in life and in death. So I wanted to agree with the court on that aspect of the religious or moral basis. Then, lastly, we say the court should not give orders in vain. It must give orders that are, in essence, enforceable. So, how enforceable are these? In my research, I tried to look at the enforceability, and I looked at the distribution of the estate of a deceased intestate man in Islam. Um, there's a portion definitely that will go to the to the heirs after all the other sub, all the other entitlements have been removed from the estate. The net intestate estate of a deceased Muslim man definitely has a portion that will go to the children as primary heirs. So why can't we, if after the court has determined that this illegitimate child is entitled to the estate of the father, have a portion that goes to the son, regardless of however much um, unequal it might be to the other legitimate kids, but they still deserve a portion. What if the deceased man had taken in the child during his life, but he failed to provide for by way of a will or wasiya? Should this kid suffer? Should this kid only be limited to enjoy from their mother's provisions? In conclusion, the Supreme Court upheld the decision of the High Court and the Court of Appeal. Then, um, of course, it issued the letters of administration to the first and the second wife. Then it returned the matter back to the High Court so that the court should consider the distribution of the estate. Yeah, I would love to hear what you think, your insights, your comments, your reactions about this judgment, whether you agree with it, whether you don't, what you find faulty. Yeah, and let's engage in the comment section.